There may come a time in your life when you are considering giving away any property you own, perhaps to your children, other family members, or even to close friends. Giving away a property is a major decision and not one which should be entered into lightly. There are a number of factors to consider before making any decision to proceed. There are several instances where you may lose complete control of your home, even when it has been passed on to your children. It is important to bear in mind that if you do give your home away to your children or to anyone else, they would then be able to evict you at any time. While this may not seem like a possibility now, you do not want this instance to ever arise. Additionally, if the new owner passed away before you, the house would then belong to whoever it is left to in their estate. If the new owners were to divorce any spouses, any interest they have in the house could be at risk of being passed as part of a divorce settlement. Finally, if the new owners were to become bankrupt, their part in your house would be an asset which could be used to settle their debts. When you own a property, there is always the option to remortgage or raise a capital sum from the property. Once it has been passed on, you will not have this option available to you. By passing on your property to your children, this will then be counted as an asset for them. If in future they ever needed to be means tested to see whether they qualified for any social security benefits, this asset would almost certainly be included. Something that many people don't realise is that the court has the power to set aside any gifts that you make to an associated person if you were to become bankrupt within 5 years of making the gift. Children are included in the term associated person. Some people are tempted to give away property in order that the capital will not be used to pay for their residential care. However, there are a number of things to consider here. If your home is still occupied by certain people, the value will not be included in your capital anyway. These people include a spouse, a civil partner, or someone who you live with as though you were married or civil partners, close relatives aged over 60 or under 60 if they are incapacitated, or a child aged under 16. If it appears as though you have deliberately given away property to avoid paying for care fees, then the local authority who manages this financial support can choose to still include the value of the property in your capital. They can also choose to ask the recipient of the gift to pay the amount required if the gift was sent within 6 months of the means testing. Do remember that the value of your property will be included in any inheritance tax calculations as part of your estate for 7 years after giving it away. While capital gains tax is not payable on a gift of a person's main residence, the house may not be your children's main residence, and if they sell your house in the future, they may well be liable to pay capital gains tax on the difference in value between the later sale price and the value at the time of the gift. So what can you do? Many people continue to live in their properties after giving them away to their children, either for free or by paying rent, which secures more right for them. However, the option that is most sound is to put your property in trust. A trust is a legal arrangement where someone or a group of people are made responsible for assets for the benefit of another group of people. There are a number of benefits of setting up a trust for your property. For instance, it can help you to avoid paying as much inheritance tax and avoid paying for care fees from the value of your property. A firm of solicitors specialising in trusts will be able to help find the best solution for you. To find out more information about trusts and passing on property, contact Dean Solicitors today on 01603 767671 or visit our website at www.gordondeansolicitorslllp.co.uk.